Hello friends, welcome to Study with Harshit. Today I am going to share with you complete revision of Unit 3rd, Business Environment and Legal Aspect of Business. Law of Contract. The law of contract is that branch of law which determines the circumstances in which a promise shall be legally binded on the person making it. According to Section 2H of the Indian Contract Act 1872, an agreement enforceable by law is a contract. A contract is a legally enforceable agreement that creates, defines, and governs mutual rights and obligations among its parties. A contract typically involves the transfer of goods, services, money, or a promise to transfer any to those at a future date. Essentials and types of contract. A valid contract should have all essential elements including offer, its communication meeting of minds, acceptance, communication of it, acceptance, consideration, capacity, legality. The two main essential elements of a contract are an agreement and enforceable of this agreement by law. Express contracts. A contract made by word spoken or written. Quasi contract. In such a type of contract, the rights and obligations arise not by an agreement but by operation of law. E-contract. An e-contract is a contract made through the digital mode. Implied contract. A contract inferred by the conduct of a person, the circumstance of the case. By implies contract means implied by law, that is, the law implied a contract through parties never indeed. Executed contract. An executed contract, both the parties have performed their promise under a contract. Executory contract. In a executory contract, both the parties are yet to perform their promises. Unilateral contract. A unilateral contract is also known as a one-side contract. It is a type of contract where only one party has to perform his promise. Bilateral contract. A bilateral contract is one where the obligation or promise is outbounding on the part of both the parties. It is also known as a two-side contract. Valid contract. If the contract entered into by the parties and satisfy all the elements of a valid contract as per Act, it is said to be a valid contract. Void contract. Section 2J states as follows: a contract which cases to be enforceable by law become void where it cases to be enforceable. A void contract is one which cannot be enforced by a court of law. Voidable contract. Section 2I defines that an agreement which is enforceable by law at the option of one or more parties but not at the option of the other or other is the voidable contract. This is fact means where one of the parties to the agreement is in a position or is legally entitled or authorized to avoid performing his part, then agreement is treated as become voidable. Such a right might arise from the fact that the contract may be brought about by one of the party by misrepresentation and hence the other party has a right to treat it as a voidable contract. Illegal contract. Illegal contract are those that are forbidden by law. All illegal contracts are hence void also because of the illegality of their nature. They cannot be enforced by any court of law. In fact, even associated contract cannot be enforced. Contract which are opposed to public policy or immoral are illegal. Similarly, contract to commit a crime like supadi contract are illegal contract. Unenforceable contract, a type of contract which satisfy all the requirement of the contract but has technical defect is called an unenforceable contract. A contract is said to have a technical defect which does not fulfill the legal formalities required by some other act when such legal formalities are compiled with later on the act become enforceable. Void agreement not enforceable by law and is without any legal effect. Void contract, valid at the time of making but become void subsequently due to change in circumstances. Definition of offer: an offer is a conditional proposal made by a buyer or seller to buy or sell an asset which become legally binding if accepted. An offer is also defined as the act of offering something for sale or the submission of a bid to buy something. Essentials of a valid offer: the offer must be communicated. Communication or expression of the willingness by the offerer to enter into a contract to obtain from doing is too essential for a valid offer. Here, desire of willingness to do or not to do something is not enough and will not constitute for an offer. Terms of the offer must be clear and defined. Knowledge of the intention of the parties is very essential, as without this, the court will not be able to decide what the parties want to do. Therefore, the term of the offer must be clear and defined and not loose. Must create a legal relationship. It is essential for valid proposal that it must be made with the intention of creating a legal relationship. Otherwise, it will only be an invitation. A social invitation may not create a social relationship. An offer must lead to a contract which creates legal obligation and legal consequence in the case of non-performance of the contract. Definition of acceptance. The Indian Constitution Act 1872 defined the acceptance in section 2b: when the person is whom the proposal has been made signified his assent there to the offer is said to be accepted. Thus, the proposal, when accepted, become a promise. Therefore, once an offer is accepted, it cannot be revoked because it has become a promise which creates a legal obligation between the parties. Example: Anita offered to buy Priya car for rupees 10 lakh and Priya accepts such an offer. Now it has become a promise. Essentials of valid acceptance. Section 7 of the Indian Constitution Act 1872 lays down two essentials of a valid acceptance: must be conditional and absolute. Conditional acceptance will not be a valid acceptance as it would amount to a counter offer which would null or the original offer. Must be expressed in some usual or reasonable manner. If the offerer does not describe any prescribed manner, then it must be expressed in the normal and reasonable manner, that is, as it would be the normal course of business. Consideration, definition, and essentials. Consideration is the price for which the promise of the other is brought. Consideration means quid pro, which means something in return. Consideration plays a very significant role in the contract. Gifts at the desire of the promiser, give by promise or any other person. It may be in the past, present, or future. It must be real, certain, and lawful. It may be positive or negative. It need to be adequate. Exception to the rule: no consideration, no contract. Exception: when gift actually made between donor and donee, any gift actually made will be valid and binding even though without consideration. In order to attract this expectation, there need to be natural love and affection or nearness of relationship between the donor and donee, but the gift must complete. Doctrine of privity of contract, capacity of parties free consent. Privity is a doctrine of contract law that say contracts are not only binding one on the parties to a contract and that no third party can enforce the contract or be sued under it. According to Section 10 of the Indian Contract Act 1872, to constitute a valid contract, party should enter into the contract with their free consent. Consent is said to be free when it is not obtained by undue influence or fraud or misinterpretation, misrepresentation, or mistake. Legality of object. The legality of the object in contract that the consideration and the object of a contract are considered legal except when they are significantly forbidden by law. They are fraud in nature. The nature of the object and consideration in such that it defeats the purpose of the law. Performance of contract. Performance of contract, Chapter 10 and 11, Section 7181 of the Contract Act of Nepal. Performance of a contract may takes place when the parties to the contract fulfill their obligations arise under the contract within the time and the manner prescribed. Section 74 of the Contract Act. Each party to a contract has to fulfill its obligation under the contract. General rule: the parties to a contract must perform or offer to perform their respective promises. Termination of contract. The most common way to terminate a contract is just to negotiate the termination. If you want to get out of a contract, you just contact the other party involved and you negotiate an end contract to that contract. There may be a fee to pay for cancellation. You might want to offer some type of consideration to cancel. Sale of Good Act Essentials. The essential of sales constraint under the Sale of Goods Act are two parties: the goods for sale, the price for which the goods will be sold, and the transfer of general. Difference between sale and agreement to sale. We discuss first one: sale. The property in the goods passes to the buyer and along therewith the risk. It is an executed contract. The seller can sue the buyer for the price of the good because the passage of the property therein to buyer. A subsequent loss of destruction of goods and liability of buyer, breach on the part of the seller gives the buyer double remedy. Agreement to sale. Since the property in the goods does not pass to buyer, the risk also need to pass to him. It is an executory contract. Such loss or destruction is the liability of the seller. The seller, being still the owner of the good, may dispose of them as he like, and the buyer remedy would be to file a suit for damage only. Condition versus warranties. Condition, a requirement or event that should be performed before the completion of another action, is known as condition, where warranty is an assurance given by the seller to the buyer about the state of the product that the prescribed facts are genuine. And other these are the differences between condition and warranty. Rights of unpaid seller. There are mainly two kinds of right of unpaid seller, that is right against good and right against buyer. The unpaid seller can sue the buyer to recover the price, damage and interest on the non-payment of money. It can also exercise the right to lien, stoppage or resale against the goods. I hope you like this video. This is the complete revision of Unit 3rd. Thank you so much for watching this video.